Hello, everyone. I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this open government lesson. Before we begin, a quick ask from all of us at NEFAC. As you know, we provide these lessons as a public service to you. So please consider returning the favor and supporting our work by visiting nefac.org and clicking Donate. Any amount is appreciated, and every dollar goes to our critical education, advocacy, and defense efforts. Thank you. Today's class is an update to the many public record presentations now available in our FOI guide. I strongly encourage you to view those lessons prior to watching this one. All our lessons are cumulative, starting you off with the basics and then moving into more complicated, nuanced areas of the law. What you learn today is intended to catch you up on the changes to the law since our introductory lesson 4 years ago. You can find that lesson and all others at nefac.org/FOI guide. Also, I'd like to recognize the estate of Gloria L. Negri. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. You can learn more about Gloria and other NEFAC supporters at nefac.org/supporters. During today's presentation, please introduce yourself in the chat and share your own experiences and resources. You can also use the chat or the Q&A button to ask questions of our instructor, and we'll get to as many of those questions as possible. All right, let's begin. Lia, all yours.
My name is Lia Ernst. I use she, her pronouns. I'm the legal director of the ACLU of Vermont, where I've been for just over 10 years now. I'm also a former NEFAC board member. As Justin mentioned, we've done a number of these presentations over the years, and so this presentation will be focused just on getting you up to speed on changes that have occurred in the past several years. Let's see. So just a quick disclaimer, we assume familiarity, as Justin said, with the basics of the Public Records Act as outlined in those prior presentations. I won't be able to give specific legal advice on public records disputes you may be having, but certainly happy to answer general questions about how the PRA works and how these updates might play out going forward. So we'll talk today first about some statutory changes since 2022, relevant case law since then, a few proposed changes as we're looking ahead, and then, as Justin mentioned, we'll have some time for Q&A at the end if you have any questions. So we'll dive in with statutory changes in effective July of 2022. 1 VSA section 316I was amended to make clear that it's the requester, not the agency, that gets to decide whether records will be produced in a non-standard format, whether the agency will create a public record or convert a paper public record to electronic format. So this is a pretty minor change, but something that folks had come up against occasionally, where an agency thought that these were entirely within its discretion as opposed to the requesters. That same year, the legislature added a new exemption for records related to a utility's cybersecurity program. This is obviously responsive to concerns about hacking and cyber threats, and so just sort of updating the Public Records Act to keep pace with the times. In March of 23, the exemption for the list of names compiled or obtained by Vermont Life magazine was repealed. This is in recognition of the fact that Vermont Life magazine ceased operations as of 2018, so this was just a vestige of another time that no longer needed to be littering our Public Records Act with yet more exemptions than it already has. And then in 25, this one is important. It exempts certain records related to professional regulation, medical practice, license and certificates registration. And this was part of a broader change to several of our laws in an effort to create a comprehensive shield law, in particular for folks accessing or providing gender-affirming care or reproductive care. This is responsive to the fall of Roe v. Wade and other hostile states seeking to potentially prosecute folks providing or receiving this care within our borders. So this was part of a larger act seeking to protect access to and provision of those types of care. Switching into recent case law, in McVeigh versus Vermont School Boards Association, we'll step back a second to an earlier case, Human Rights Defense Center v. Correct Care Solutions. In that case, the Vermont Supreme Court determined that a private entity providing healthcare within DOC facilities is an instrumentality of the state and therefore a public agency within the meaning of the Public Records Act. So as you might recall, the Public Records Act defines a public agency broadly as any agency, board, department, commission, committee, branch, instrumentality, or authority of the state, or any of those of a political subdivision of the state. Several courts, both inside and outside of Vermont, had adopted what's known as the functional equivalency test to determine when and whether a private entity was performing so essential a government function that it should be brought within the Public Records Act, notwithstanding its private status. And so in one articulation of that test, courts would look at whether the defendant entity was performing a government function, obviously, look at the level of government funding for the private entity, the extent of governmental involvement in or regulation of the entity, and whether the entity was in fact created by the government. So in HRDC, the court held it doesn't even need to reach that question of whether to adopt the functional equivalency test, because here, where the state was contracting with a private entity to discharge the entirety of a fundamental and uniquely governmental function, an obligation the government owed to its citizens, that entity is in fact an instrumentality of the state and therefore constitutes a public agency within the definition of the PRA. And so it said, you know, this private healthcare provider is an instrumentality. We don't have to answer the question of whether to also adopt the functional equivalency test. But here in McVeigh, the court explicitly rejected the functional equivalency test, saying that the word instrumentality within the PRA was broad enough to get at the sorts of entities the legislature intended to bring within the ambit of the PRA. And it went on to hold that the Vermont School Boards Association was not an instrumentality of the state and therefore not within the PRA. And this, you know, this distinction between instrumentality and functional equivalency test, in many cases, there's a large overlap between those two tests. And so several entities that might have been brought in via the functional equivalency test will also be brought in via this instrumentality test. So it's not a huge difference, but I think there will be some parsing there as the courts sort of figure this out with different types of entities. Next, we'll look at Pierce versus Town of Shelburne, Vermont. In this case, the question presented was, what does it mean to substantially prevail for purposes of determining whether an award of costs and attorney fees is mandated? Now, you might recall many years ago, the legislature changed the statute to say that a plaintiff who substantially prevails in a public records case shall be awarded, not may be awarded, costs and fees. And so the courts have been sort of grappling over the years with what does substantially prevail mean. And in this instance, the plaintiff said, you know what, I sued, and then the town produced 1,200 pages of documents. They produced them in the standard electronic format as I'd requested and had previously refused, and therefore I substantially prevailed. And the Supreme Court disagreed because they said the town was already in the process of trying to provide these materials when the case was filed. It had voluntarily hired a company to provide them in electronic format requested. And so, you know, that the town produced all this so early in the litigation means for purposes of fees and costs, the plaintiff had not substantially prevailed because arguably he would have gotten the same exact thing if he just waited until the town finished its work it had already started pre-litigation. Next, we have Vermont Journalism Trust v. Agency of Commerce and Community Development. This was an ACLU case along with Cornell's First Amendment Clinic. In this instance, we were looking at the exemption in 317C14 for records relevant to litigation to which the agency is a party. In this instance, and so that exemption says these records are broadly exempt except they must be released after rule discoverable by the court before which the litigation is pending. And of course, on the final termination of the litigation at latest. And in this instance, the trial court said, you know what, litigation, in this case, the other litigation was the Sutton EB-5 litigation. The exemption no longer applies. It doesn't need a rule discoverable order by that other court. And so that was, I think, an important development because otherwise an agency could avoid having to produce documents in the public records case and continue to rely on this relevant to litigation exemption, even after the documents had been produced to the other party and the interests sought to be protected by this exemption no longer apply. We also unfortunately lost on our request that the state be ordered to provide what's called a 318b2 index. This is the statutory obligation to justify exemptions and withholdings. And in this instance, the court said, look, all of the records withheld are without dispute subject first to the litigation exemption and secondarily to attorney-client privilege, because that was the basis on which they hadn't been voluntarily produced in the Sutton litigation. We did appeal that to the Vermont Supreme Court. It was fully briefed, fully argued, but before the Supreme Court ruled, the Sutton court granted the plaintiff's motion to compel those same records. So all the records were produced to the Sutton plaintiffs and to the plaintiff here. And so the Supreme Court held that the case was moot and did not rule on what 318b2 requires, unfortunately. And so that's still a bit of an open question. Next, we'll look at energy policy advocates versus the Attorney General's office. This relates to 317C4's exemption for records protected by a statutory or common law privilege. In this case, work product privilege. And here the court held that you can claim work product privilege even if the records were produced before litigation was actually underway. There was dicta in an earlier case called Killington v. Lash suggesting that there had to be an actual litigation in order to protect the records that were produced and prepared. And in energy policy advocates, the Supreme Court stepped back. The Vermont Rules of Civil Procedure protect from discovery documents prepared in anticipation of litigation or for trial, unless the party seeking that record can show a substantial need for the records and an inability to procure the information by other means. And so this is codified in the Rules of Civil Procedure, but it's also a common law privilege that predated that. And here the court held that the Attorney General's office didn't waive this protection by sharing confidential communications with other states' attorney generals pursuant to what's called a common interest agreement. And this is just sort of a contract. Different parties who are not part of the same litigation can nevertheless enter into in order to share confidential information without, the intent and purpose of this is to not waive any sort of privilege by sharing this information because we have a collective common interest in pursuing the same means, and sharing this information will materially aid us in doing so. And so here the court looks at what is the waiver of the work product protection, and it happens when you disclose to an adversary or you disclose to a non-adversary in a way that materially increases the risk that the adversary will get that information. And so here the court looked at the documents at issue, looked at the common interest agreement and said, no, this didn't increase the risk it would go to an adversary. It didn't waive the privilege. It was to unify its strategy and conserve its resources. And so the court said, no, this is not a waiver. And this from a access to public records perspective, obviously this is not a robust endorsement of the Public Records Act, but from an effective litigation and from the purpose of why entities might enter into common interest agreements, I think this is the right outcome. And the court also held that the common interest agreements themselves were protected by work product privilege, contrary to what the trial court had decided, because they also talk about the parties' mutual interests and they say, we want to keep all communications confidential. The next case, Rivard v. Wyndham State's Attorney, this was just a pretty straightforward application of prior precedent that the exhaustion requirements in Section 318 are jurisdictional. So if you don't request records from the custodian, you don't say this is a public records request. In Rivard, they had made a discovery request in the course of a criminal proceeding, not a public records request. And if you're denied, you have to appeal it. If you don't follow all those steps, you can't have your claims heard in the Superior Court because the court lacks jurisdiction if you haven't exhausted all of those administrative procedures. Heyer v. Slate Valley, this was a case about records that are statutorily mandated, where schools must keep records of instances of restraint and seclusion. And the court held that these are categorically student records and thus exempt within the meaning of 317C11. The plaintiff had argued if you redact the student names, they're not student records, but they're records about the school and its practices. But the court rejected that. You see the language there. It contains information related to a specific student, details of an incident involving the use of restraint and seclusion on that student. And so the court held just across the board, these are exempt. And because it's a blanket exemption where we're looking at what type of record is it, not what is the information in the record, we can't just redact and we can't do a Trombley-style public interest, privacy interest balancing. There's no balancing to be had. It's simply, if this is this type of record, no matter what's in it, no matter what you redact, it is exempt. Okay, that's it for the case law, and now we'll move quickly into the last few minutes here of proposed amendments that are pending this biennium, amendments to the Public Records Act. H22 would amend C7, which is the personal documents exemption, to ensure that records related to severance payments and benefit extension agreements for public employees are available to requesters. This is, a pro-government accountability, pro-transparency proposal. It would also add a new provision that would allow courts to award punitive damages up to $2,500. So, not going to break the bank, but hopefully enough to encourage folks to comply in good faith with public records requests. But here, if the court finds the agency acted in bad faith in either withholding records or delaying access to them, it could award these punitive damages. It was introduced with 11 co-sponsors in January of 25. It had one hearing in House GovOps, and we don't know, what sort of activity might happen here in this second year of the biennium. H95 is a comprehensive overhaul and reorganization of the health insurance chapter, but it does include one provision saying that 317C9's exemption for trade secrets includes confidential business information received from a health insurer under this other obligation to provide this information to the Green Mountain Care Board. In the first year of so it had one sponsor. In the first year of the biennium, there was no committee activity. Don't know what its prognosis is going forward in this second year. H335 would make employers and subcontractors working on state construction projects, would require them to maintain and preserve accurate payroll records and would subject those records to access under the PRA. Was introduced with 11 co-sponsors, had no committee activity in the first year of the biennium, and again, unclear prognosis going forward. And then this one comes around pretty regularly. It's been introduced in both the House and the Senate. What it would do would be to permit agencies to charge for staff time associated with complying with a request for copies or a request to inspect records. So this would be a legislative overruling of the Supreme Court's decision in Doyle v. City of Burlington Police Department. This was also one of our cases. You might remember Doyle was the case that looked carefully at the structure of the PRA throughout and noted that the PRA treats requests to inspect and requests for copies very differently and puts different obligations on the agencies and puts different responsibilities on the requester. And so if you request copies, you can be charged for the staff time associated with making those copies, less the first half an hour, the actual costs of making copies, actual costs of transmitting copies. Whereas if you make a request to inspect records, that is to go into the agency and look at the records they have, even if the agency has to spend all the same time redacting and preparing the records for your inspection, the agency cannot charge you for that staff time. And, this was, different people had different feelings about this. Obviously, the agencies often didn't love it. And so this comes up regularly in the legislature, whether they should legislatively overrule Doyle. One of the strongest arguments against it is that, well, several. One is that these costs can be absolutely prohibitive for some folks, and it just means a denial if they're being charged this. It also serves a sort of efficiency forcing function. The PRA does direct that agencies maintain their records in such a way as to allow efficient responses to public records requests. And if folks are able to inspect records for free, agencies can't sort of lard up the bill with all this time trying to find records in disorganized and ill-maintained files. So this sort of is an encouragement for agencies to really heed that legislative mandate to keep their records in order. This was introduced with one sponsor in the Senate and 10 co-sponsors in the House. No committee activity in either the House or the Senate. And again, we expect this will come back around from time to time, but so far this change hasn't been made, and we will continue to advocate against it. And that's it. That's it for the updates that I have. If there are any questions from any of you, I'd be glad to try to answer them.
Thank you, Leah. Very comprehensive and much needed update. Appreciate it. Just one question before we wrap up here, and I'm going to have you look into your crystal ball here into the next 4 years. Are there any changes to the law that either you foresee happening or personally would like to see happening that you can kind of inform us about? So maybe when we reconnect for another update 4 years down the road, we can look back and take stock in what happened.
Yeah, I mean, I do think that, the drum I'm constantly banging on the Public Records Act is it has an absurd number of exemptions. There's just no reason for it. There's 40 whatever in Section 317 itself. Plus, there are exemptions littered all throughout the statutes and different titles, different codes. I mean, Legislative Council can't even keep track of all the exemptions. And you look at the federal FOIA, and there's a small handful of exemptions, and that's worked fine. And so one thing, so the legislature has put in place a sunsetting provision for any new exemption. It sunsets after 5 years unless recodified. So that helps us sort of pare down new unnecessary exemptions, but it doesn't do much to deal with the 100 whatever exemptions that already exist. I would also, we've tried time and again in various cases to get some sort of limiting principle on the relevant to litigation exemption, because it's very broad as the courts have interpreted it, and it can last for years and years and years. If there's just one case after another, it's potentially limitless. And so we've been trying in several of our cases to get some limiting principle, but failing that, I would love for the legislature to take a look at that and see whether it's really serving the interests, balancing the interests between public accountability and transparency and management of the discovery process in the way that it intended. And this exemption doesn't exist in the FOIA context, and the federal government hasn't fallen to its knees because of it. So those are a couple that we've been looking at and interested in. We do have a case right now against the Essex County Sheriff's Department where we requested records. The department said, we requested copies of records, and the Sheriff's Department said, fine, you can come inspect. And then once you inspect, you can pick which records you want copies of. And we said, no, we're electing to receive copies, so go ahead and send them our way. They refused. It's been now a couple years of litigation over this seemingly simple question, and so were we to lose this case, which I don't anticipate we would, I think the statute is abundantly clear, but were we to get a ruling that agencies get to choose as between inspection and copying, or put a prerequisite of inspection in order to exercise your right to receive copies, we would very much want the legislature to clean up that mess.
Great. Well, let's hope for a favorable ruling there. And thank you again, Leah, for this lesson and for all of these updates. Really grateful for your time. And many thanks to everyone who joined us today. Again, we provide these lessons as a public service to you. So please return the favor and consider supporting our work by visiting nefac.org and clicking donate. Your contributions are critical to our mission and protecting the public's right to know in all 6 New England states. Thank you again for your interest in keeping government open and accountable. And thanks, as always, for being a part of our growing NEFAC community. We'll see you all next time. Take care.